Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. Let's start our morning with Judge Dad.
He was referred for a screening and assessment, and he also pled on file B. The charge was failure to stop a short, clear distance, and that was reduced to distracted driving. So have you had a chance to review the report with him, and are there any material additions, corrections, or deletions? But before you do that, I need to inquire whether or not the victim appeared. We did send notice to the victim back on April 22nd. Is there Amada Ali Jones here? Amada Ali Jones here. All right.
Judge,
Yeah.
I have one person in the waiting room I can't identify. I just brought him in so we can double check.
Motorola, Moto G Power, what's your name, please? You have to unmute and tell me your name. What's your name, sir? You have to unmute and tell me your name. Bottom left-hand corner of your screen. I can't hear a word that you're saying.
There we go.
What's your
Can you hear
name? What's your name?
His name's Stephen Charles Bailey.
You're going to have to get a lot closer to the device. Your last name's Bailey?
Yes, sir.
All right, we're going to mark your name there. Just be patient.
Okay.
All right, so it does not appear as though the victim has appeared. The case was scheduled for 8:30. I did give him 15 minutes. You can go ahead and proceed. Is everything in this report accurate? And are there any material additions, corrections, or deletions?
Your Honor, the only couple of things with respect to the report. On page 2, it says there's an X towards the top. It says will benefit from the treatment services below. The X is applied to the inpatient/residential treatment.
I'm not going to order inpatient.
Okay, and because the recommendation suggests intensive outpatient.
All right, I know. I don't know why we have that on there, and they check that sometimes. I'm with you.
So I kind of conflicts with it.
I know it does.
And now we ask the court to, if it's inclined to suggest outpatient treatment be ordered, I would first request that an assessment be made to see exactly what the needs are before actually ordering the intensive outpatient.
Well, it did. We did though. She scored in category 5. That's mandatory. I mean, it's the worst, right? Category 1 through 5 on our screening. 5 tells us he has a serious problem. 1 tells us he has no problem.
I would still suggest that it be submitted to an evaluation first to see exactly what his needs are. And with respect to
Do you have the UD-10 by chance? Did he drive into the back of a tractor?
no, it was a semi-truck.
Well, that's what I mean. It doesn't say tractor trailer. It doesn't say how the accident occurred. Boy, you got to be careful. All right, go ahead. What else?
Also, with respect to the term of probation, we would ask the court to consider a 1-year term rather than 18 months. He has been attending AA consistently 2 to 3 times per week. He's currently working 2 jobs. He's been on the alcohol tether. He's not had any violations with that. Otherwise, I think this has been a real learning experience. He has both of his parents here today.
Where are they? I'm glad you came. Who's paying for all that college? You or your parents?
My parents paid for the first 2 and I'm on for the rest.
I mean, I'm just telling you, you got all this seemingly going for you. This is not good. And this is not good. That's all I'm telling you. You start to affect your future, you do things like this. That's a really high breathalyzer for a 21-year-old. So I don't want to sit here and lecture you, but I'm just going to tell you, when people come in here and they're 21 and they have that kind of a result, I mean, you're over 2 times the legal limit or thereabouts. and you just were able to start drinking legally, and you're lucky you're not dead, right? You gotta be careful. I mean, we got Ubers, we got Lyfts, we got taxis, we got friends, we got family. They can come get us. I don't care how much you drink, but you can't go out and drive like that, okay then? And you're not gonna drink on probation. I wanna be clear about that. We understand one another, right?
Yes, sir.
And this was a breathalyzer, right?
Yes.
So the cost of recovery will only be $150. I interrupted you, counsel. I apologize. What would you like to
That
tell
was
me?
all I had to say, Judge. I mean, I think he's trying to turn the page from this event, and like I indicated, he's got support from his family.
That's important. I'm glad they came. Thank you. All right. Anything you would like to say?
I mean, I'm just, I learned from this mistake, and I've been getting a all these stories and realized that I could have gone down a slippery slope, and I think I really.
Do you have your AA verification with you?
What was that?
The AA verification.
Yes.
I just want to make sure that since April 16th, when I increased it, he was to do once a week between March 26th and April 16th, and then I increased it to 3 times a week. So there should be at least about 13 or 14 of those on there since that date.
I believe so.
There's 12, Your Honor.
Is that including all of them?
No, that's just the,
The second page
Oh, I didn't see this.
has 5 on it.
Yeah, he's got like 17 on there though.
All right, good enough. I'm sorry, I interrupted you now. My apology. What would you like to say?
that, I would like the silver link to be decreased or, removed because it is very hard to, my sleep schedule is so different. Because I work nights on one of my jobs, and work mornings, my second job. So like the times are a little hard to get some sleep and stuff. And I understand that you don't want to pick up, I get it, but. And then that's also just,
They're recommending weekly testing. How much are you paying for that SoberLink again?
it's $6.50 a day. So I paid $2.56 when I came here on the 26th, I believe.
You gotta take your hat off, sir.
And I then paid another $70 to get another 10 days to get up to the 26th of this month. So I still, if I do another month, I still owe like, I believe, close to 200.
I'm gonna give him his choice. I'll either take off the SoberLink, but then he's gonna test weekly for several months. Or if he keeps the SoberLink, I'll just order bi-weekly, which is probably gonna be a lot. I don't know, that's gonna be cheaper, but
You would prefer to do the random weekly.
all right, good enough. Have I listened to everything else that everybody has to say? Did I let you finish?
So what was that?
I just want to make sure I've let you finish. With whatever you want to say to me.
That learned a lesson and I believed I understand if I woke up drunk and I thought I was good to drive, that I was drinking too much. I understand that.
How long were you sleeping?
What?
How long were you sleeping?
I was sleeping for about 6 hours.
All right, so I want to do the math with you.
Yeah, and you said last time it was like a 2.26, I believe.
Well, it's about an hour, 1.15 for every hour. So you were up 9. So that means you're somewhere around over a 2.5. Now that is way, way, way too much for anybody to be drinking, especially a 21-year-old. Got it?
And I usually, I didn't eat that night either, so that's why
I don't care if you ate, didn't eat.
So I just truly thought I'd be okay. It's not like
That scares me, and it should scare you. And I mean, I'm just telling you, I'm not gonna make this worse for you, but it should scare you. Actually, it's
No,
scary.
I did. And I had to get up and take the exam that day, so I was.
So you're out drunk? How are you doing in school?
I was doing online, but I had to go in person for this exam.
I don't care. I didn't ask you that. How are you doing in school?
Oh, I'm doing fine.
I don't know what fine means.
I got a.
Fine could mean a 3.9, it could be a 1.1. I don't know. People have different,
Currently, I have a 3.5.
you believe.
Yeah.
You don't know.
Well, I got, last semester, I got,
Listen,
286
listen. You're kind of making this worse for yourself, you know that? And I don't mind listening in. You seem like a nice kid. I'm glad your parents are here. But if you're going to take an exam the next day and you got a 2.5, 2.6, I don't want to ask you how you're doing how you did on the exam. But if you'd have spent that time studying instead of drinking, I bet you'd have aced it. Now, it's a lot of money to go there, right? Right?
Yes.
Okay. I just want you to reflect on what you're doing, and you are kind of making this worse for yourself. It's okay. I'm not going to be an ogre here with you, but I want you to stop. You got to stop. You got a problem. I don't mean to be the bearer of bad news. You got a problem when you're 21 and you're drinking a 0.25, and I can tell you statistically, I don't keep numbers here. I got enough to worry about, but I'm only telling you the likelihood of you not returning to the criminal justice system on another drunk driving or something similar there too, where you're intoxicated, is extremely high. That's all I'm telling you. It's your life. I don't want you to hurt yourself. I don't want you to waste your money going to college and have somebody tell you, well, we can't hire you. You got all these convictions on your record. And I want you to think about what you're doing. I mean, how much is it a credit hour out of curiosity there now?
It's about 6,000 per semester.
And do you live there or you live at home?
I live at home.
Ah, still $12,000 plus books, right? It's a lot of money. Counsel, I'm going to place him on probation for 15 months. I heard everything he said. I asked him for his idea. He's staying on the sober link to continue until June 21. This is not intended to be punishment. It's intended to help you. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming fruit or other items containing those substances will be deemed a violation. Do you understand that?
For the poppy seeds?
Yeah, because I've had people come in and tell me, oh, I'm positive because I had everything bagel. That's not working in here. So that's why I put it right in here.
So no everything bagels? I mean, because
Listen,
I only have.
don't eat a bagel. Don't eat a bagel. It's not gonna kill you.
Okay. Yeah.
What's that?
So get the flame.
Sober link device. You remain on that until June 25th. You're to submit to chemical testing, PBTs and ETGs weekly for 3 months, then bi-weekly for 2. Then I'll revert you to monthly, okay? You're to continue to attend AA 3 times a week until you're in an intensive outpatient treatment program. I'm ordering intensive outpatient. Once you get into intensive outpatient, you no longer have to attend AA or NA. You're to attend the victims. Do you understand that? So if you get intensive outpatient this week, you don't have to go to AA or NA, but you're going to go 3 times a week until you're in intensive outpatient treatment. You're to attend the victims impact panel. That's one night put on by Mothers Against Drunk Drivers. 5 days jail credit, 1 serve 4. I'll let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that. They'll set you up. You're coming at the end of the year, so you can be able to, school year, I should say, if you're not already there. So they'll set you up in the summer to work 3 court work program days. 1 day of community service. I'm going to let you complete that. I'm going to give you until, I'll tell you what, I'll give you until July the 7th to complete that. Pay fines $300, cost $200, $75 victims' rights fee, $50 justice assessment for 6 1/4. Screening fees $60 for 685. Probation fees are $300. You also have $150 in costs of recovery. 5, 6, 7, 6, 8, 9, And you have $105 in court work program fees. Should be $12.40. Will you double check my math, Lisa? If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Also, if you do everything and you stay clean and there are no violations within the preceding 90 days and 7.5 months, by law, you can come in here and seek early discharge, and it'll be granted. That's by law. You understand that?
Yes, sir.
So no marijuana, no alcohol, no illegal drugs. Do you understand the sentence fully?
Yes.
Do you have any questions at all?
What is the,
And by the way, restitution, if any, is to be handled through civil litigation, and you're not to have any contact with the victim in this case. You cannot write, phone, send, text, email, or communicate with or have anybody else communicate with the victim. Amadi Ali Jones, okay? I'm sorry, what is your question, sir?
there's that question about the outpatient. What is that?
Intensive outpatient.
And what does that entail? Like
I'm
what?
gonna let probation explain that to you. You're gonna be going 4 times a week.
4 times a week, plus the 3 times a week at AA?
Okay, so you're gonna just do AA until you're in intensive outpatient,
Okay.
okay? Counsel, good to have you here and see you as always. You're always a gentleman. I appreciate it. Can you pay this today or does he need time?
How many times?
How much do you have with you?
On me?
Yeah.
Like $50.
You're not gonna wanna pay your insurance. How much can you pay per week? I'll be reasonable. Can you pay 50 a week or not?
I can be 50 a week.
You pay 50 now, you pay $50 weekly. I'll begin that next Friday, which is June the 2nd. I can't believe we're into June already, Mr.
Judge, there's also a B case.
Oh, yeah, 195. I wrote that down and I didn't say it. 195 on that case. So I'm gonna let you work that out by just paying that one. Thanks, Lisa. Pay that by October 1. I'll let you pay that by October 1, okay? Wish you well, good luck. You'll meet with probation, go down and pay your $50 and then meet with probation. Thank you, counsel.
Thank you, Judge. Good luck.
You too. Matthew James Kills.
All right, wisdom of the crowd is 50-50 that Captain Fidget there will get his life sorted. Hopefully he does, but ultimately I think what you have to do if you find yourself in these situations is find a way to weave it positively into the tapestry that is your life and learn from it, but so many people seem to not. So good morning again. Welcome to the Courtroom Files Live. Nice to have all of you here today. I just glanced to the left and realized I never ate my breakfast this morning, so we're going to switch over to Judge Simpson, and while we watch him, I'm going to wolf down some cold eggs and bacon.
Let me recall that. I think the poly was off.
That's good.
Can you hear me now?
Yes, Your Honor. You talking
Mr.
to me?
Deanne? All right. Yeah, I'm going to recall the case. State of Michigan versus Mohammed Deanne.
Good morning, Ashley Lundy for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mohammed Janan, who appears via Zoom from the MDOC facility. Sir, can you please state your name for the record?
Mohammed Janeh.
Thank you, Your Honor. I have discussed this matter briefly with my client this morning. He was recently transferred to a different MDOC facility, so to that end, I was unable to visit with him either via video or in person prior to today's date. So I'd be requesting a brief adjournment so that can happen.
What's my date?
2 weeks.
You want the 4th or the 18th? Well, it's two weeks exact on the 4th.
Yes, sir.
Maybe.
Maybe the 18th.
Sounds good, Your Honor.
Thank
Thank
you,
you.
Your Honor.
I'll adjourn the matter June 18th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Deanne.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of the people versus William Parker.
Ashley Lundy for the people.
Morning, sir. Tom Pietrowski on behalf of Mr. Parker, who's approaching and standing to my right. Right, sir.
Name, sir?
William Parker.
All right, what do we do?
This is scheduled for an arraignment. We'd waive formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
We're asking for a pretrial. I believe I've confirmed this with your clerk at June 14th. Please.
14th.
Yes, please. June 18th. I'm sorry. Thank you.
I'll adjourn this matter to June 18th, 2025, 9 a.m. As to bond.
Good afternoon.
Your Honor, this is an alleged OWI second offense of the prior offense in 2022. People are requesting that the defendant be placed on a scram or a sober link.
Just go around the
One
bump.
crash, the defendant was stopped after being observed engaging in bad driving. And the alleged VAC in the matter is 0.129.
Your Honor,
0.129.
Yes, Your Honor.
I think sober link is reasonable to request, Your Honor. We would concur.
All right. Set the defendant's bond at a personal recognizance, $15,000 bond. All order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes, I do.
There should be no possession of any alcohol, recreational marijuana, or any illegal drug. I'm also going to order that you report to community corrections for placement on a sober link testing device. All right, and I'll sign that.
Thank you.
order.
Thank you.
All right, thank you. Want me to set those to the side? Court does call the case of the people versus Kamara Reed.
Ashley for the people.
Morning, Your Honor. Dan Garrett on behalf of Ms. Reed. She's stepping forward.
Good morning.
Good morning, Your Honor. Kamara Reed.
For arraignment, we would waive reading and stand mute, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
I'm ultimately asking for another pretrial mid-June if possible due to my client's requested travel, which I'll address in a second, as well as travel I have.
All right. Pretrial in this matter then will be June 18th, 2025, 9 a.m. As to bond.
Here, this is an alleged OWI first offense. There's no crash. Alleged BAC 0.099. We are requesting
0.99.
Probably soberly in this matter. No priors, Your Honor.
No crash.
No crash.
All right. It's a traffic stop. Is that
Traffic stop for no headlights. I think of note at the scene, it was a 08. And as it relates to any testing, I do want to address travel when Your Honor's ready.
all right? Set her bond at a $10,000 personal recognizance. All other standard conditions, including no assaultive behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drug. Given the BAC level, I'm not going to place her on a testing device at this point.
Your Honor, I appreciate that. One of the things we added it. Let me say this a different way. She's asking to go to Arizona today, leaving in like 2 hours. I was going to adjourn, but Ms. Lundy and I agreed to just do that today. So she's asking permission to.
If I said no, what happens?
She's staying right here with us. That's what happens.
Why are you going to Arizona?
My cousin's graduating high school.
Family that graduates. See, Karen knew that.
I did know that.
Yeah, and it's gonna. How long? Today through
The 31st.
the 31st. It's a long graduation.
And family reunion.
Leave that out. All
Your
right.
Honor, one thing I did want to mention, but I neglected to, I apologize for the interruption, is that the defendant at the time of the offense was 20 years old. She had not yet
Oh,
21.
she
So
has not yet turned 21.
that's correct.
Okay, that changes. Thank you.
I apologize for the interruption.
All right. So I will indicate that the defendant may travel to Arizona today. I am going to order community corrections. I am going to order that she be placed on a sober link device, given that there's an age issue.
Could she go right?
She can go right now.
Good.
They're usually watching, but if they have a problem, they can call in.
Sounds good.
Usually people don't run over there asking to be put on a device. So
Get her over there right now. Thank you.
all right.
Sir.
Thank you.
Thank you.
Have fun in Arizona.
Yeah, get down here before it gets much hotter. Real quick, while he's between contestants, Vicky, you said earlier that you missed this morning's members only. Those are available for replay, so you can go back to the member page and catch it there. Anyways, back to Judge.
David Chan, on behalf of Aaron Salazar.
Yeah, Your Honor.
We do, Your Honor, we do have a plea in this matter in return for the super drunk charge being dismissed. My client will plead to OWI first.
That's correct, Your Honor. The 93-day misdemeanor, $100 to $500 fine, 6 points from his license, and various other Secretary of State sanctions, contrary to 257-6251A. Will dismiss the OWI high VAC. There had recently been, not a violation, but a progress report cautioning the defendant to remain compliant with his sober-link device. Mr. Shan had shared with me some of the explanation as to why there was that late/miss test. So I'm satisfied with that explanation and ready to move forward with this plea should the court accept it.
All right. And that's a correct statement of the plea.
Yes, it is, Your Honor.
All right,
He cleans residential houses and he takes SoberLink with him. And he left it at a residential house that he cleaned and then had to go back and get the owner to get the SoberLink out of the residential house so he could do the testing. So that is what happened.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Aaron Salazar.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days of jail, a $500 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
And understanding that, do you still wish to plead guilty?
Yes, I.
And to that charge, how do you plead?
Guilty.
Yes, I'm guilty.
You pleading guilty?
Guilty.
All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
No trial.
No trial.
That's the stuff that we went through. Yeah.
You understand that you will not have a trial, sir.
I'm sorry, boss.
Do you understand there'll be no trial?
Oh, yeah.
All right. You signed an advice of rights form today, is that correct?
Mm-hmm. Yes, sir.
All right. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form.
You understand these?
Yeah, I understand.
All right. You understand you're giving up those rights.
Yeah, you're waiving those. You're giving them up.
Yeah.
Okay. Is he understanding me?
Yes,
Because I've got to make sure that he does.
Yes, he does. And that's why I'm slowing down because you speak really quickly and he does.
So that's the second insult Shane has given my court today. The first one when I wasn't out here, but was reported to me.
I did that.
No,
that is
you
not
said
an
it, and
insult.
I know you said it. Now you just did that. Now, that first one was about how hard I think I work my staff.
It was an honest,
and then this
honest
was just
statement.
a direct attack on me. All right. So no, I won't hold that against you. All right. But is he understanding?
Yes, he is.
Yeah. All right. So you understand you're not going to have a trial. You're waiving all of the rights that are on this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah. I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No.
All right. Have you ever been to prison for longer than a year?
Okay.
Have you ever been to prison?
Yeah.
Have you been to prison?
The prison where?
In the United States? Have you ever been to prison? Not jail, prison.
Yeah.
Okay. Counsel approach person.
Well, that's a little bit of a curveball there. They're going to have to deal with, it looks like. Can't believe drunk driving is a misdemeanor. Yeah, but honestly, it's so prevalent. If it was a felony, our prisons, I think, would be overflowing, to be honest with you. And there are accelerators if you, depending on the area, if it's like a third DUI or a fourth DUI, you're definitely into felony territory for sure. So, what are you going to do?
Record should reflect that it had a bench conference with counsel. I'm going to stop the plea at this time. I'm going to adjourn this matter out June 4th, 2025, 9 a.m. And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Sarah Orr.
Testimony for the people.
Sherilyn Foster Tucker on behalf of Sarah Orr.
Sarah Orr, Your Honor.
Thank you. All right.
Can we read first?
Briefly, yes. Never going to get through this.
His lawyer was surprised. You've been to prison. Yeah, his lawyer was definitely surprised. That was a curveball right there for sure. So while we're waiting for him to come back, if you're not already a channel member, consider becoming one. $2.99 a month. It's relatively inexpensive. All that money goes right back into the channel. You get some excellent extras, including a pre-show that we do 30 minutes prior to this show for just our members. This morning, we talked about all of the people I know who are in prison. And it's a few of them. So we had story time, and I think it was fun. If not, you can feel free to tell me in the chat, and I'll never do anything like that again. But I think we all enjoyed it. So be interesting to pick that up in June. Yeah, hopefully we're able to catch it and see what's going on with it. All right, we'll hang here for Judge to come back and then move forward. Michael, thank you for clarifying what it is here in Arizona to get into a felony territory. Which state is this based in? We're currently watching Judge Simpson. He is in the state of Michigan, Washtenaw County, which is the Ann Arbor area. I really enjoyed your stories. Thank you, Barbara. Again, we did that in the pre-show. If you'd like to join us in the pre-show, all you need to do is become a channel member. I missed a good one to add. Have a good one to add to that topic. Well, Kazman, the pre-show is available for replay, so you can go watch it after this. And you said you have a good story to add to that.
Like we've got a bench conference.
Email it to me using my email address. We can cover it tomorrow.
Plead to an added count of failure to report $1,000 damage accident, 90-day misdemeanor, $100 fine, and 0 points, contrary to MCL 257622. In exchange for that plea, count 1 will be dismissed.
That is correct, Your Honor. And Ms. Orr does wish to accept that offer today. And I have handed the court an advice of rights form.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Sarah Orr.
No. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of failure to report an accident. It's damage over $1,000. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You
Sorry.
signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane and we were at the red light, and when we were driving through, I got in front of him and then he got into the turn-in lane, and then he says he was gonna turn, but I don't think he was, because of the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
heading,
we collect-
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from Ann
So
Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right, where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station?
not.
You did not. Would you dispute that the aggregate amount of damage that can include repair cost was in excess of $1,000?
For mine or for his?
Total.
So you obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it
You'll
was over
stipulate
1,000.
The damage, total amount of damage to both vehicles was in excess of 1,000, including repair costs. You'll stipulate to that, counsel. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
June 25th. At 9 a.m.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, Bond, we'll continue. You'll stop down at probation on the way out. Just
Okay.
to check out. All right.
Okay, thank you.
Thank you, Your Honor.
Thank you. Court does call the case.
So I don't know if you all caught it, but that gentleman on his shirt said Uncle Ed's oil. So I looked it up. Uncle Ed's offers a 10-minute oil change. So I can't do it while I'm live, but one of you feel free to hit the rewind button and tell me if he got his oil change done in 10 minutes or not as promised, because I'm honestly curious. Let's go back to Judge Simpson for a little bit longer.
That case is
Let's not go back to Judge Simpson because he muted again. Let's go to Judge Mom, Judge DeSanto.
All right, the court does find the plea is knowing knowledge and is actually accurate after we do the police report. The court will accept your plea for the plea agreement, and we will see back for sentencing, sir. You'll have to see the information. They'll do a pre-sentence interview, and then they'll give you a pre-sentence interview date and sentencing date, and the court will determine whether or not you're eligible for your 771.1 status. Okay.
Thank you, Judge.
If you were to test today, sir, what's in your system?
Marijuana, that's it.
Okay, when's the last time you used it?
Yesterday.
Okay. That was my condition, so you're all good. Have a good day. Stop the probation.
Thank you, Judge.
Conditions are continued.
Thank you.
Thank you. And then we are on the record in the matter of City of Wyandotte versus Tyler Cazzo, 24200.
Good morning, Your Honor.
Good morning, Mr. Cazzo. Mr. DuBois? Oh, isn't that him right there on the screen?
I think that's cool.
Okay, we will recall your matter, Mr. Cazzo, because your attorney's in the breakout room.
Yes, ma'am.
So we just a couple minutes. All right, we are on the record in the matter of the City of Wyandotte versus Sienna Atwell, 25639.
Attorney Corey Westmoreland appearing on behalf of Ms. Atwell. Ms. Atwell, would you please state your full name for the record?
Sienna Atwell.
All right, and today's date scheduled, good morning, today's date scheduled for the arraignment and for the pretrial in this matter And counsel, as to the pretrial.
Yes, Your Honor, at this time, the city attorney has offered to amend the original charge to one count of operating while visibly impaired, and my client would like to avail himself of that offer and enter into a plea.
I'm sorry. Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give this going to be the truth, the whole truth, and nothing but the truth?
Yes, Your
All
Honor.
right, thank you. And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating while visibly impaired by alcohol, how do you plead?
Guilty.
You've gone over your rights and rights with your attorney, correct?
Yes.
And you understand all of those rights?
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No.
Counsel, if you can please run your client.
Sure. Ms. Atwell, were you operating a motor vehicle in the city of Wyandotte on May 8th of this year?
Yes.
On that evening, were you pulled over for speeding and driving inconsistently?
Yes.
On that evening, did you consume any alcohol?
Yes.
What did you consume?
I didn't hear that, ma'am.
Yes.
Okay.
What did you consume and approximately how much?
I had a few beers.
And by few, how many?
I had 3, but they were of a larger size.
Like 24 ounce?
Yes.
And did that impair your ability to operate a motor vehicle?
Yes.
Satisfied, Your Honor?
The court is also satisfied the plea is knowing, involuntary, and factually accurate. And counsel, do you stipulate as to the,
I believe it was a .14. .14.
yes. Yes, .145, yes. I stipulate.
We'll stipulate, yeah.
Okay. All right, the court does find the plea is knowing, involuntary, and factually accurate. The court will accept your plea to the amended charges, dismiss the original charge per the plea agreement, and you will receive your sentencing date from probation. The court's going to order bond and conditions are continued, and you're going to stop at probation. You're going to receive your needs assessment information. You're going to receive your pre-sentence interview information, your date for your pre-sentence interview, and your date for your sentencing. So you'll be getting a lot of stuff from over there. And if you were to test right now, ma'am, what's in your system?
Marijuana.
All right, when's the last time you used any marijuana?
2 days ago. I do have a medical marijuana.
Okay, and how long do you have that card, ma'am?
I've had a card for about 2 weeks. I see my doctor every night.
Okay, and it's your treating physician?
Yes.
Okay. Okay, please step over probation. Thank you.
Thank you, Judge.
All right, have a good day. Okay. And we
Judge Simpson is back, so we can go back to him and see if we can get this oil change guy taken care of.
I don't have him there either.
Your Honor, I did speak to him.
Borello Beavers? We have no response.
Your Honor, I did speak to him and did anticipate that he would be here today. I don't have an explanation for his failure to appear. For the record, I'd request an adjournment.
Beavers? No, not here. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately.
Thank you, Your Honor.
Let's call the cases of the people versus Byron Blair.
People. Assistant Public Defender Natalie Pate, on behalf of Mr. Blair, Your Honor, who I do not believe is present.
Cedric
Blair. Oh, Cedric Blair.
Hello, who are you? That's Cedric Blair. That's not Byron.
I believe so, Your Honor, based on his voice. So as to Mr. Byron Blair, Your Honor, he does not have a working phone number. He is usually a resident of the Delana Center. I did send him an email and I did not hear back. To that end, I do not have an explanation for his failure to appear, and for the record, would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege on it. Thank you. Court does call the case of the people versus Cedric Blair.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cedric Blair, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Cedric Blair.
All right, what are we doing?
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading no contest to the added count of retail fraud in the third degree, and in exchange, count one will be dismissed.
That's correct, Your Honor. That is contrary to MCL 7503560 as in dog 4, 93 senior $500 fine or trouble amount.
Sir, please raise your right hand. You'll need to unmute now, Mr. Blair.
I was trying to.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Cedric Blair.
All right, you can put your hand down. Mr. Blair, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that becomes the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
If I may, Your Honor.
Or plead no contest, I'm sorry.
Thank you. That's what I was just about to say. Excuse me, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand about it is it means that the court is going to treat you the same as though you had pled guilty for the purposes of sentencing. You understand that?
Yes.
Basis of the no contest plea.
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
That's correct.
Any questions regarding any of those rights?
No, Your Honor.
You understand that you'll be giving up your trial rights, which are described in paragraph 5, as well as all of the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? That was a question, sir. Are you on probation or parole? Did he freeze?
Yes, he did. He's here though.
There we go.
He's
There we
right.
go.
Okay. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 2416486. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Before satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue. I don't have probation. I do. All right. Bond will continue. Sir, wait on the line. We're going to put you into a breakout room with my probation department so we can start the sentencing process.
Excuse me. Hello?
Yes.
You said I'm just automatically on probation? I'm just curious.
I didn't say that.
Oh, okay. That's why I was asking, Your Honor. No disrespect.
All right, but my probation department will interview you and will make a determination. So you need to wait on the line. You'll go into a breakout room with my probation department so we can start the process.
Okay.
Thank you.
Thank you, Mr. Blair.
Court calls the
Thank
case,
you.
People versus Candace Brooks.
Requesting to practice pursuant to
You
Michigan.
got to come closer to the microphone. This is your first time doing this, right?
Yes, Your Honor.
Okay, go ahead.
Okay.
Take your best shot.
Your Honor, Christina Barrick-Darian requesting permission to practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Wandy.
I won't embarrass you by going through the series of questions. I did that the other day. I know where you're from, where you are, right? You're at Wayne State, right?
Yes.
Okay. Good school. You like Wayne State? No. You do? Okay, we'll let her practice. Permission to practice is granted.
Your Honor, Christina Barrick-Darian for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Ms. Brooks, can you unmute and state your name for the record, please?
Candace Brooks.
Okay.
We are requesting an adjournment. Just want a little bit more time to talk to the people about a potential offer.
Hearing no objection, I'll adjourn this matter June 4th, 2025, 9 a.m. Thank you. Court calls the case of the people versus Jason Brooks.
The people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Oh, thanks. Please state your name.
Jason Brooks.
Thank you, sir.
Your Honor, I am requesting an adjournment. I was unable to speak with Mr. Brooks prior to today. I'll get updated contact information, just make sure we have the right number for him before he leaves the building.
All right, June 4th, 2025, 9 a.m.
Thank you.
Thank you, Mr. Brooks. Court calls the case of the people versus Zachary Burlett.
That's the line of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Burlett.
There he is. Okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did you say?
Just getting my notes pulled up there.
Oh, okay.
One moment to draw my screens. That's correct, Your Honor. We are going to be dismissing this case.
Certainly no objection to that.
Case is dismissed. All right. Thank you, Mr. Burlett. Take care.
Have a good day.
Thank you, Mr. Burlett.
Court.
Well, we were watching him change oil so long, that's kind of anticlimactic now. I'm sad. Let's go Bay County, Florida. Judge Brantley Clark.
Witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which would be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Mr. Herp, are you doing this of your own free will?
Yes, sir.
Do you feel this admission is in your best interest?
Yes, sir.
All right. And I'll accept the basis, I think it was failure to report and find there was a basis for the admission. I'm going to find that Mr. Herp's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. His probation is revoked. He's adjudicated guilty of felony petty theft. He is sentenced to 22 months in the Florida Department of Corrections, given credit for 214 days time served. All monies previously imposed and not paid are reduced to a civil judgment. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. That's also reduced to a civil judgment. Mr. Herp, you have 30 days to file your notice of appeal if you wish to appeal this judgment sentence. If you'd like to have an attorney to represent you and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. You can step over and be fingerprinted.
Good luck, Frank. This guy. Mr. Craig. Any questions? Judge, this is Noah Craig in case 19-1415. He's prepared to admit having willfully violated the terms of supervision by failing to report. He has been living out of state for a while. The agreement we've reached with the state is that his supervision would be modified. He'd be adjudicated guilty. It would be extended to 36 months from today, adding back any told periods of time. The next.
He was gone. I was told him the time that he was gone.
Okay, but I need you to tell me how much time we're holding. Typically.
It's 36 months. That's about what I count. That's what I counted there.
Tell me.
I know he absconded for 5 years, so we should be able to do that, but if there's questions.
Right, that was, because I think he reported for 2 of those, the first couple of years, was the way I saw it. No? Okay.
I'm not sure, but.
That's how I read it. You know if I'm wrong.
Yeah, it's good.
Okay.
I think.
Yep.
The next 12 months would be on community control 1. He's going to be living here in Florida. There's an additional $250 cost of prosecution for today's proceedings, and all prior conditions are reimposed to the extent they remain incomplete or modified by this sentence.
That's the agreement with the state. Yes.
Raise your right hand. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Craig, you lower your hand, sir, and state your name.
Noah Craig.
Craig, you heard the announcement of Mr. Meredith. Is that correct?
Yes, I did.
Is that your understanding of the agreement with the state?
Yes, sir.
Did anybody promise you anything different?
No.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read this agreement?
Yes, sir.
Have you had the opportunity to go over your violation report with Mr. Meredith?
Yes.
Have you had sufficient time to speak with Mr. Meredith about your case?
Yes.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to go to trial or go
Yes,
to
I
have an
do.
evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Okay. Yes,
You're
sir.
waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses to the allegations that you might have.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which is be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Craig, do you feel the admissions in your best interest?
Yes, sir.
I am going to find there's a basis. I'm going to find that Mr. Craig's admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. Probation will be modified as follows. It'll be extended 36 months from today's date. That's adding the total time in when he was out on warrant. There was a warrant status. The next 12 months will be on community control 1. He'll be adjudicated guilty of grand theft. All conditions that were previously imposed and have not been completed will be reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation. Mr. Craig, you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You step over, be fingerprinted, and speak to the probation officer.
Thank you.
Bo Langclose. Judge, we haven't been able to reach an agreement. The state has come down to 24 months. We're scheduled for an evidentiary hearing this afternoon.
All right, we'll come back at 1:30 this afternoon for the evidentiary hearing.
I mean, you're positive UA. He's not coming down past 24. You'll get the 24 months. You'll get at least 24 months.
All right, have a seat. If you want to do something this morning, we can do it. But I gotta take a break in a little while. So if you want to, we can take care of this morning or this afternoon.
Andy Rhodes. Judge, you may or may not recall Mr. Rhodes is doing some good work in the
I do
jail.
recall it.
In fact, they brought him back for Hell Week at Resilience just recently. By agreement, we're passing his evidentiary hearing. So if we could have the July return date.
That's July 23rd.
It is.
July 23rd at 9 o'clock and at 1:30.
And if Mr. White and I come up with something, we'll get back before you.
Sounds good. Thank you.
Everybody's got it.
Derek Taylor.
Ooh. Y'all take your time getting out of that box now.
Judge, Mr. Taylor's scheduled for an evidentiary this afternoon, but he was, I can't remember if he was ordered in or volunteered, but he's in the Lifeline program right now. We're asking to continue the evidentiary till August.
Any objection?
No, Your Honor.
All right, we'll set it for August the 20th at 9:00 and 1:30.
And Joshua Williams. Your Honor, you appointed Dr. Burney to evaluate Mr. Williams. We got the report. I think it was just filed this week. I've had a chance to review it. I'm not asking for any additional doctors, a second doctor. I'd ask that you rule based on the report before you.
What I'll do, if you had a chance to review the report, Mr. White, is the state asking for another expert?
No, Your Honor.
I'm gonna find that Mr. Williams is incompetent to proceed at this time, that the least restrictive measures available is to remain in the Bay County Jail and allow life management for the restoration. What we'll do is we'll set it for a status review. There's less than 30 days. Let's set it for June, that 21st.
You want a motion?
Be a motion. No, BOP.
18th.
June 18th. Let's see where we're at that time. Okay?
Yes, sir.
Shepard?
Morning, Your Honor.
Morning.
Let's head back to Michigan and see what's going on with Judge Mom.
And asked to the arraignment.
My client waives formal reading and stands mute to the charge.
For waiving the formal reading, enter plea of not guilty for purpose of the arraignment and ask the pretrial counsel.
Yes, I've had an opportunity to review this matter with the client and as well as the city attorney. At this time, we're asking the court to accept a plea agreement. My client's prepared to plead guilty as charged with the condition that the matter be taken under advisement pursuant to section 771.1 if eligible, and he does appear to be, no prior criminal history whatsoever.
All right, Mr. Landry, please raise your right hand. You solemnly swear or affirm the testimony you're about to give this is going to be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, and you heard the plea that was placed on the record, correct?
Yes, Your Honor.
As to that charge, sir, how do you plead?
Guilty, Your Honor.
You've gone over your rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights?
Yes, Your Honor.
You also understand that by entering into a plea that you'll be waiving some of those rights?
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency?
Yes, Your Honor.
You understand what the 771.1 status is?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, you still want to continue with your plea, correct, sir?
Yes, Your Honor.
And okay, Wayne County Jail, please hit join for the breakout room. And any immigration issues.
No, Your Honor.
Wayne County Jail, please hit join. Sir, in the Wayne County Jail, hit join, please. All right, and counsel, if you can please order your client.
Yes, I will, Your Honor. Mr. Landry, you recall being in the city, in fact, at your home in the city of Wyandotte on or about the 4th of March? Yes, sir. And at that time, you were apparently outside, maybe working in the garage, and something drew your attention going down the street. Is that correct?
Yes, sir.
And that happened to be a motor vehicle, which you had seen apparently numerous times before, speeding, driving recklessly up your street.
Yes, sir.
In this particular instance, you didn't let that vehicle go by unmolested. Is that true?
Yes, sir.
You in fact threw an object at it out of anger.
Yes,
Is that
sir.
correct? And you did cause some damage to that vehicle. Is that correct?
Yes, sir.
Your Honor, I'm satisfied.
All right, and what is the object that you threw, sir?
It would have been a blowtorch.
You threw a blowtorch?
I did. Yes, Your Honor.
Okay, do you know this individual?
No, Your Honor.
You just don't like people driving down your street when you thought it was 90 miles an hour?
Well, we've, throughout the years that we've lived at that address, we've had, 3 cars, completely totaled in the same exact, location that the, incident occurred in. And, it was just, it just happened. It was, impulse, and I was working on something in the garage, and it was in my hand. It was just an impulse move.
So do you live on a corner?
I do.
Okay. and
Yes,
so
I'm sorry.
What are the cross streets for your corner?
Antoine and 11th Street.
Okay.
You point out,
And we do have,
Mr. Lenny has 3 small children, his wife, they own their home there, they've lived there many, many years. He's involved in this community, he's a T-ball coach, and he lost his temper. And he's here and he admits it, he admitted it to the police officer. So, I think the police broke under the circumstances.
Okay, and sir, have you been in contact with Wyandotte Police Department?
as far as,
The vehicles that speed down your street?
not formally, no.
You should.
Okay.
If you have concerns with traffic enforcement or traffic control, right, perhaps you as an individual will not be able to control the traffic, and clearly you can't throw objects at vehicles. So I'm just suggesting, since you have concerns regarding people continuing to speed down the street, perhaps that's one way you can try to address that. The court's going to continue your cash bond. You're not to have contact with Dominic. What's his last name?
Crow, I believe.
Crow, yes. Do you know him other than that incident?
No, ma'am, I'm familiar with the vehicle.
Okay, well, don't contact with the vehicle here. Okay. All right, please stop, have a seat over probation. You received your pre-sentence interview information, your date for your pre-sentence interview, and your sentencing date.
Thank you, Your Honor.
Okay, good luck to you. Okay, this one's all to you, Abby. Okay, and I have to laugh because they put the book there so that, we elevate the microphone and some people are sticking around there and tap it, which is completely. Okay, we are on the record in the matter of the city of Wyandotte versus Nicole Cochran, 231335. Okay, where did Mr. Cole go?
He's in a breakout.
Okay, I'm sorry, we have to recall this matter. Oh, there he is. Look at that. Perfect timing. Ms. Cochran.
Okay, sorry.
Okay. All right, and so, counsel, your appearance, please.
Your Honor, John Goldthorpe, E30758, on behalf of Ms. Cochran.
Okay, and we have your name for the record, please.
Nicole Lee Cochran.
Okay, so you were, to have been here back in 2023. And, well, you finally came in on April of 25. Someone's phone just went off.
Might have been my, it's not my phone, but I will remove my phone just to make sure.
Okay. Okay.
Sorry about that, John.
Oh, that's okay. That's That's right. Okay, and so, I'm sorry, Counsel, your appearance, please.
Again, John Goldclaw, P 30758, on behalf of Ms. Cochran.
Okay, and I'm sorry, Ms. Cochran, your name for the record, please.
Nicole Lee Cochran.
Okay, and so today is the date scheduled for the arraignment pretrial on this matter as your client posted a bond in April. And counsel, as to the arraignment.
Your Honor, we've had extenuating conversations regarding this. As to the arraignment, she would stand mute to the charge, waive a formal reading of those charges, ask that a plea of not guilty be entered.
All right, the court will waive the formal reading, enter a plea of not guilty for purpose of the arraignment, and then as to the pretrial.
As to the pretrial, Your Honor, as I've indicated, we've had numerous discussions. I've spoken to Mr. Cochran. I've also spoken to her father, who is present in court today. He's been present. And I have reviewed all the materials that were provided. Based on that review and based on my discussions with the prosecuting attorney, it's been determined that Ms. Cochran would plead guilty to the charge of R&O because the R&O is not anything physical. She was no resisting arrest, but rather in the statement and in the discovery that was provided, she was during a conversation. She was detained by the police department, basically for safekeeping, and they brought her in on an alleged violation of probation because she was to have no contact with a gentleman by the name of Nathan Braden, I'm sorry. And they were having contact because there had been a series of phone calls made over a period of time where threats were made, or that Mr. Braden was claiming that Ms. Cochran was being held under by Mr. Brownlee. And this went on and on. And
Oh, David Brownlee?
yes,
Oh, yes, I remember that.
right. And
Well, I mean, I don't remember this particular,
yeah,
but hold on, because there were two women. You were one of the women? No, you were not. There were two other women in jail, because I remember they were all trying to play kissy face on Zoom. I remember all that.
and well, this is
Sometimes my memory is a curse, but.
yes, and she and Ms. Cochran was being held. I guess similar to that. She had made a number of complaints, but she was being threatened by Mr. Brady to say what she said. She was threatened by Mr. Brownlee, and Mr. Braden and Mr. Brownlee were in cahoots, for lack of a better term. So when she made these reports, she knew they were false, but she was fearing for her life, not only from Brownlee, but also from Mr. Brady. She did make statements to the officers at the time she was detained on the probation violation, and then made a statement to, I believe it was Detective Carr, I may be wrong on that, under Miranda. Oh, I'm sorry, no, it was under, the statement was made, I believe, I'm sorry, I think now the assistant chief, but it was,
Deputy Chief Rowe?
I believe it was, I'm not sure. It was. And when she made those statements, they wanted her to kind of help out, admitting certain things, and she was fearing for her life. So there she is at this point in time.
So she didn't cooperate, is that what?
Well, she said, I don't want to cooperate, and then the charges were brought. So, pardon, yeah, exactly. Right. And so she wasn't aware, I mean, of this outstanding warrant until she was notified. I know that the record showed that she was supposed to be here on a particular date, and she went when she was, you were on probation.
I was on probation for Judge Simpson and Judge McNally, and I had that court date the same day, and then they sent me to rehab that same day.
So the day that she was supposed to be here originally, she was in custody in Judge McNally's court. And she also had matters in front of Judge Hessen. and she was sent to rehab for mental health treatment. That's why she disappeared. She wasn't aware of this date. So for those reasons, and she's come in and we've addressed it. So at this time, she would ask the court to accept the plea to guilty to the charge. There is a recommendation for costs and fines in this particular matter.
Sorry, Ms. Baumgarten was the other individual that was in the jail.
That's correct.
And then there was a third person or second female. So, Leanne. Okay, so please raise your right hand. Many people are doing it, so sorry. You solemnly swear from the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
And you heard the plea that was placed on the record.
Yes, ma'am.
And you may lower your hand. As to the charge of resisting and obstructing an officer, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And Counsel, I want to see you and Mr. Keeley in chambers before we proceed.
Thank you.
Mr. Keeley? Mr. Keeley?
Okay.
Okay, thank you. Okay, so
Everyone, please rise.
All right, well, she steps out for a minute. Let's go from Judge Mom over to Judge Dad.
All right, Ms. Rowe,
Yes, ma'am.
go back on record. So if you plead guilty to this added count, and that's what it is, right? She's gonna plead guilty to disorderly person fighting, and they are going to dismiss the A and B, and the plea is going to be taken under section 771.1, right?
Correct.
We'll talk about why you don't show up in court later, okay? If you plead guilty to under section 771 to disorderly person public intox, I'm gonna go ahead and dismiss the A and B. The possible penalties here are up to 500 fines, 90 days jail costs, or all those. I'll send you for a report. I'll place you on probation. I'll sentence you later. I'll set terms and conditions. If you're compliant, the prosecutor will move to dismiss, and that case will be dismissed. Do you understand that?
Yes.
Did you sign an advice of rights form and read it and understand it today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand me?
Yes.
All right. You understand everything?
Yes.
To the charge disorderly person, public intoxication, how do you plead?
Guilty.
Were you in the township of Brownstown on April 1 of 25,
Yes.
and what happened? What makes you guilty of disorder? Did you drink alcohol?
No.
Your Honor, I don't think it should be public and.
Wait a minute, maybe I misread it. Hang on a second, maybe I misread it. I'm sorry. Sorry, disorderly person fighting, I apologize. Did you get in a fight?
No. It was verbal. It was verbal, but it didn't escalate.
Well, I need either a factual basis on the original charge or on the added count.
Okay.
Did you threaten somebody?
Yes.
Did you get in a fight?
No.
Who were you threatening?
My sister.
And were you threatening her enough where you think she was scared?
Possibly. Yes.
Why are you fighting with your, why is everybody fighting with their family now? I don't get it. Well, how old's your sister?
We're the same age, 27.
Why are you guys fighting?
You don't get along.
Your Honor,
Okay.
her sister put coffee grounds on her car and.
She's
escalated from there.
purposely poured coffee on my car because she doesn't like me.
All right. Are you on probation or parole?
No, no,
Anybody force you to plead guilty?
no,
And you're satisfied?
satisfied with it.
Please accept it. Let me just take a look at this. You guys are twins, is that what you said?
Yes,
You guys should be tied at the hip in a good way, not in a bad way.
we used to be, but we were apart.
Why?
People change.
Takes two to tango though, right?
Right.
Maybe you can accept some responsibility ultimately too, right?
Yes,
Do you work?
yes.
Where at?
I work at a warehouse called GXO.
All right. I don't even know if I need, let me just check something. You know what, I'm not even gonna order a pre-sentence report. I'm gonna accept the plea, dismiss the A and B. I do feel like I still have to notify the victim. So we're gonna do that, and we'll notify the victim. I'll take a sentence date, the A and B is dismissed. So we need to make sure, John, that they notify in probation. Go ahead, Lisa.
June 18th at 8:30.
June 18th at 8:30 will be your sentence date, okay? You still can't have any contact with that Elisa, but hopefully she'll show up and we can have a conversation here, okay?
Thank you.
Wish you well, good luck, thank you very much, thanks.
Thank you.
Do you have WMI or somebody else? WMI Real Estate Management, 2588-255-18. Do you have the lawyer out there, Lisa?
Yep, they're joining right now.
Good morning.
Morning, Your Honor. Kevin Bowling on behalf of Brownstone.
How are you?
I'm well, Judge.
Counsel, your appearance?
David Poirier on behalf of WMI.
Hey, Mr. Poirier, I've had the pleasure or not before to have you in here a couple times.
I have not been in, Your Honor, so this is your first pleasurable moment.
But you're a lawyer.
Yes, I am, sir.
And why has your client been playing with me? I don't appreciate this. They didn't show up March 13th. I know you probably weren't representing them. I said the issue of show cause versus the president of the corporation for failure to appear. I also ordered, and then he didn't appear again. So I ordered another show cause. What does he think? Who is this gentleman? Is he with you today?
He is not, Your Honor. We filed an appearance and we were given a Zoom.
Well, he's still got to show up here. I don't appreciate him. Who does he think he is, ignoring court orders like this? I'm dead serious. I don't want to get off to a bad start with you, but these guys that think that they can just do whatever they want and not show up, I want them on here. Can you call them right now and tell them I want to see them? This is a show cause against him for failure to appear. We don't have staff time. We don't have an abundance of staff where they can sit around and do paperwork all day long and only to have it ignored.
Your Honor, we received a pretrial notice, not a show cause.
Judge,
Well, there was a show cause.
We show cause the owner, but then we got an appearance from the attorney and set it for an arraignment pretrial today.
Yeah, and that show cause was for April 23. And he didn't show up. Mr. Kira. We show caused him, and he was supposed to be here. And I said bench warrant to issue versus the principal of the corporation, Rashab Kira. So he still should have a warrant out for his arrest, does he not, Lisa?
He does not.
You didn't enter it when you got the appearance?
No, we have to get that information. I don't have all of his information for a warrant, so I have to wait to get that information from the prosecutor.
What are we going to do here, counsel? What do you want to do? I want your client to show up and at least apologize that he hasn't shown up here 3 times.
Your Honor, we'll be there in person next time. I'm sorry, Your Honor. I apologize.
Listen, I don't want to get off to a bad start with you, but I don't understand these guys anymore, especially people in a business type situation that should know better. Just ignoring a court like this. What do you want to do? I want him here. It's good to have you here. What do you want to do? What are we doing on this?
Well, I thought that we would set it for trial today, Your Honor. I understand that the defendant's not been arraigned.
Well, the corporation hasn't been arraigned, but I guess on behalf of the corporation, you can stand mute and waive formal reading. Is that what you want to do, counsel?
Yes, Your Honor.
I know it because it's charged as a criminal violation, and a defendant, a corporation, cannot represent the corporation, an individual, as you know. The principal can. So I'll enter a not guilty plea. I do want your client here next time. You want to have a pretrial? What's this over?
Your Honor, this is the property that was once Capitol. It's now WMI, and they are illegally parking trucks without a site plan.
Capital. Is that the one I had before?
That's the one with Mr. Picano, representing the defendant, on Sibley Road. You did have it, Judge.
They wouldn't be doing that. Well, counsel, we're setting this in 2 weeks or thereabouts. I want your client here, the principal of the corporation here, and we will go from there. I'm going to tell you right now, if they're parking vehicles there in violation of that other order, they better start getting them off right now, because I'm not going to be patient at the end. Do you understand what I'm saying?
Yes, Your Honor.
I don't know what happened with that case. That was like one of the most ridiculous cases.
Are you talking about the prior entity, the prior owner, Your Honor?
I know, and these guys bought it from him, right?
That's correct, Your Honor.
I'm just saying, I heard so much garbage on that. Was there a lawsuit that was filed between the prior owner and your client?
I don't believe so, Your Honor.
There is, Your Honor. It's pending in Wayne Circuit Court.
So
Your Honor, our firm is not handling that. Yeah.
I'm sorry?
I apologize, Your Honor. That's another firm that's handling that, but I am aware of that now.
Did they not get the vehicles off, or am I confusing this with one of the other ones?
Your Honor, the defendant was Capital Trucking and Mr. Badun. You ordered the trucks removed. They removed every truck from the property. As you may recall, they sold the property during that process. WMI came on and they brought their own trucks on.
They better get them off. I don't know why these guys think they can do this. I'm not sure I don't. Why don't you call him right now and you tell him I want to arraign him right now? Will you do that for me, please?
I will do my best, Your Honor.
Well, I don't know why he's the man didn't show up for a show cause. I could hold him in contempt. I mean, I don't know who he thinks he is. These guys on this property over there, wow.
Your Honor,
Eagles the size of the Grand Canyon, I guess. I don't get it. Yeah, get him on here. If not, he's going to have a show cause to deal with me, okay? So please try to get him on. I'll mute you. I'll go on to another case. But these guys over there, wow. I wish I was that confident myself. I really do. Jeez. All right, so let us know. I'll be waiting here for you. Thank you. People against Dylan James Hall, 25B148235AB and
Judge DeSanto is back, so let's see if she picks up where she left off.
I know we have the jail. I don't know which jail we're doing. Okay. All right, then, Mr. Gopal, your appearance, please.
Again, John Gopal, P3075A on behalf of Ms. Cochran.
Okay, and Ms. Cochran, your name again, please.
Nicole Cochran.
Okay, and so Mr. Gopal, you had an opportunity to speak to your client after you and the prosecutor and myself spoke in chambers, correct?
That is correct, Your Honor.
All right. And so we're going to adjourn this matter. Let's go to June 25th. All right, that way it gives, council gives you a little bit more time to further review all the other associated police reports as well.
Thank you, Your Honor. And I did file a discovery order
Yes, I have the discovery order here and I signed it. What time works for us, Ally?
9:15.
9:15?
Yes.
All right. And then ma'am, our counsel asked to bond.
As Your Honor, she's posted a bond. I think under these circumstances, we'd ask that the bond be continued. She's undergoing a lot of treatment at this point in time, therapy, more than treatment. We're asking for a personal bond with obviously no drugs, no alcohol, etc.
Okay, so Ms. Cochran, if you're to test right now, what is in your system?
Absolutely nothing.
Okay, and so how long have you been in recovery, ma'am?
Well, I've only had like 2 incidents in the past, like 4 years ago. But once in a while, I do use marijuana. Not all the time for my anxiety. I do not have a card. But I
You
have
do not have a card?
Huh?
You don't have a card?
No.
Okay, so while you're on bond, you can't use it.
Yes, ma'am. I understand completely.
I'm sorry, you what?
I understand completely, yes.
Okay. All right, ma'am, it sounds as though you're in a pretty dark space, in a whole lot of ways. And it sounds as though you are working your way out of that. So I'm glad to hear and see that for you.
Thank you, ma'am.
So I think that your attorney has spoken as to why we're doing this.
Yes.
And so we're going to continue your cash bond. You're not to possess or consume the alcohol or drugs unless prescribed. And we'll see you back on June 25th.
Thank you, Your
We're
Honor.
going to sign the discovery order as well. So just have a seat, ma'am, and then you will receive a copy of your bond conditions, okay?
Thank you.
Thank you.
Thank you. Have a good day.
All right, so now we know how that concluded. So this has been a really interesting poll here. Judge Mom was in the lead for most feared, and then that last interaction, Judge Dad surged into the lead. So that's kind of interesting. But speaking of which, let's go back to Judge Dad.
It's okay?
Okay, not a problem.
All right, any questions?
No, sir.
Good luck.
Thank you.
Jose Maria Lucero, 25B148-414A and B. What are we doing on this one? Is this yours?
Mr. Calabat's on Zoom.
Mr. Calabat, good morning. Your appearance?
Good morning, Your Honor. Dan Calabat appearing on behalf of Jose Lucero, who's with me.
Sir, your name, please?
Jose Lucero.
So what are we doing? We're adjourning this?
Your Honor, I want to adjourn, but I wanted to ask if you're not done with session, can I just have another few minutes with the prosecutor? I still want to adjourn, but I wanted to just say a few things, sir. If there's no time for that, if I can just have another.
Oh, that's fine. I'll put the file aside. That's not a problem.
I appreciate it.
Okay, no problem. Alexander Michael Ray, 25B1483718 and B.
Good morning, Your Honor. Michael Crawford, representing Mr. Ray, who's approaching.
Your name, sir?
Alexander Michael Ray.
Okay. So for purposes of arraignment, how does he wish to proceed?
Your Honor, my client would like to stand immediately, formal reading.
All right, so I'm going to do so now. As I understand it, you met with the prosecutor. The client's going to plead to moving violation causing serious impairment. They are going to dismiss, once he does that, the distracted driving. True?
He is going to plead no contest to the first one.
I understand. Is that what you want to do?
Yes, Your Honor.
And the reason for the no contest plea is civil litigation. All right, so you understand if you plead no contest that it has the same effect as a guilty plea?
Yes.
Do you understand if you plead no contest that the possible penalties here are up to $500 in fines, 93 days jail, costs, or all those? Do you understand that?
Yes.
And did you sign the advice of rights and read and understand the rights?
Yes, I
You
do.
understand if you plead guilty, you're giving up all those rights. We're not going to have a trial. Do you understand that?
Yes.
And you understand you're waiving the presumption of innocence and waiving the requirement that they prove you guilty beyond a reasonable doubt by pleading guilty. Do you understand that?
Yes.
All right. Any questions on your rights?
No, sir.
To the charge of moving violation causing serious impairment, how do you plead? I'm sorry, wait a minute. Wait. I just want to make sure I cover this because it's no contest. You understand a no contest plea has the same effect as a guilty plea, right?
Right.
So if you plead no contest, we're not going to have a trial. Do you understand that?
Yes.
All right. You stipulate I can use the police report?
So stipulated.
I've had it marked Peoples 1. So do you have any questions before we go on?
No.
Now to the charge moving violation causing serious impairment. How do you plead?
Not guilty. Or no, I'm sorry.
Good, let's try it again. Do you have any questions?
No,
To the charge moving violation causing serious impairment, how do you plead?
no contest.
All right, I've had the report marked Peoples 1. All right. Based on my review of the report, I find there's a factual basis for the plea. Are you on probation or parole right now?
No,
Anybody force you to plead no contest?
no.
I'm accepting that plea. I'm dismissing the distracted driving charge. I'm going to order a pre-sentence report on this, and we're going to notify the victim. And I'm going to set a bond here. You've got a warrant out of Southgate. You going to take care of that anytime soon?
Was it double parking?
No, it looks like it was just entered a week ago. No contact with Trevor Ray, disturbed the peace, or no firearms. So you didn't show up or something. You
No.
got that.
So will you take care of it?
Yes.
Okay, that's what I'm telling you to do. I'm gonna give you a $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand that?
I do.
And then I'm gonna say no contact with the victim in this case. You cannot write, phone, see, text, email, or communicate with the victim at all. You cannot have anybody else do any of those things for you or on your behalf. So no contact at all with the victim, Teresa Coleman. Do you understand that? All right. Sentence date, Lisa.
June 2nd at 1 p.m.
June 2nd at 1 p.m. will be your sentencing date, okay? So you're gonna go down the hall, get your notice, your paper notice, and then you will go over and fill out a questionnaire. I don't know, you were never printed on this. I really need you to go over and get printed. So I want you to go over to the Brownstown Police Department to get fingerprinted and photographed
Okay.
Your Honor, will you be able to get that
by
done?
2 p.m.
Your Honor, will you be able to do that by tomorrow? I'm supposed to report in work today at 2:30. He likes to keep his
2
job.
p.m.
Where do you work at?
Lowe's in Canton, Westland.
Yeah, I don't have a problem with that.
Thank you, Your Honor.
You're gonna go, what time you work at?
From 2 to 11 tonight.
How about tomorrow?
2 to 11 as well.
So you have to be there then by
No, I'm sorry, tomorrow's Thursday, I'm off tomorrow.
noon tomorrow, okay? So we're gonna give you an order for prints too. And you're gonna take that over to the Brownstown Police Department, okay?
Yes, sir.
Anything else?
No, Your Honor.
And so after you go there, you realize, after you go down and get your notice and your order for prints and your bond sheet, you're going over to probation to be interviewed, okay?
Okay.
Thank you.
Thank you, Your Honor.
Did they ever show up, Mr. Poirier? You out there? How about Lucero? You ready on that, Mr. Calabit?
Yes, Your Honor, we are ready. Thank you.
People against Jose Maria Lucero, 25E 148-414 A and B. Your appearance?
Danny Calvert appearing on behalf of Jose Lucero, who's sitting to my left on Zoom.
Your name, sir?
Jose Maria Lucero.
You know, we've got this set for a bench trial, right?
Today's a bench trial, Your Honor? I thought it was a pre-trial.
No. Relax. No, I mean, it's set for a bench trial, June 18th at 1. Just,
Your Honor, if we come in on that day, has he waived jury? Like, if we don't resolve it, can we still set it for jury? Which we're probably not gonna, but just want to know what his rights are.
well, I would have already taken the waiver. I did take the waiver. I mean, if you want to ask me to set it, what is this? What happened? I mean,
Your Honor, it's a kind of a unique situation where I feel like he didn't do anything wrong, but I wanted time to talk to the prosecutor. I said I would call her this afternoon. Would you allow before this one more?
let's just do another pretrial. Do you have June 2nd, Lisa?
Thank you.
Yes, 2:30.
How about June 2nd at 2:30, but put that date in your book, June 18th at 1.
Will do. Yep, and I see that right here on the notice. So
June 2nd at 2:30 will be the final pretrial.
Okay.
Bench trial will be June 18th at 1.
Perfect. I appreciate it, Your Honor.
Anything else?
No, not on my end.
Have a good day. Good luck.
Good day. Thank you. Take care.
Where's your lawyer at, sir?
Let's switch it up and go back to Florida.
16 hours per month. There's an additional $250 cost of prosecution for today's proceedings, and all prior conditions are reimposed to the extent they remain incomplete or modified by this sentence.
That's the agreement with the state.
It is, Your Honor.
Yes, ma'am.
All right, Mr. Daniels, state your name, please.
Tyler Bradford Daniels.
Daniels, you just heard the announcement of Mr. Meredith, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understanding the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature of the defendant line. Is that yours?
Yes, sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your violation report with Mr. Meredith?
Yes, sir.
Have you had sufficient time to speak with Mr. Meredith about your admission?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you.
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses, come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which will be your decision to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Daniels, do you feel the admissions in your best interest?
Yes, sir.
And I'll accept the stipulation, I'll accept the basis that Mr. Meredith placed on the record and find there is a basis for Mr. Daniels' admission. We'll find his admission was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He'll be reinstated to probation. He'll complete community service work at the rate of 16 hours per month.
Yes, sir.
Through the Bay County Work Program, I'll give the Florida Department of Corrections the discretion to amend that to the direction of the probation officer. All other conditions that were imposed that have not been completed are reimposed. There's an additional $250 imposed today for the cost of the prosecution of the violation of probation.
Yes, sir.
Or you have 30 days to file your notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, you can. A 411 may be appointed to represent you at no charge. Good luck to you, sir. You can step over and speak to the probation officer.
All right, good luck. William Hall. Judge, Mr. Hall is before you in case 11-2878. State's made a 10-year DOC offer. We're going to, for purposes of today's proceedings, deny the allegations contained in the affidavit.
Okay. We need to set up for an evidentiary hearing. We'll set up for July 23rd at 1:30 and 9 o'clock that morning for a preliminary.
Thank you.
All right, I'll be back up to see you. Okay. And Mr. Prater? Your Honor, Mr. Prater has a new charge as well as this violation of probation hearing or allegation. It's set for an evidentiary this afternoon. The state had made an offer to resolve the new case as a misdemeanor time served. And on the VOP to revoke his probation, 18 months, Department of Corrections with the credit for 274 days that he had previously served with no probation to follow. I've gone over that with Mr. Prater, I believe at least twice. So we're scheduled for an evidentiary hearing if the state's ready.
All right, we'll see you at 1:30.
Also, Mr. Prater knows his maximum sentence is 15 years in the Department of Corrections.
Mr. Prater, you understand that you've been offered 18 months in the Florida Department of Corrections and get credit for any time you've served in jail on that, your exposure is 15 years in the Florida Department of Corrections.
Yes, sir.
Okay, we'll see you at 1:30.
All right, as I have been doing lately, trying to bring a new thing every day. This will be today's new thing. We're going to go to
Thompson?
There we go. Hold on. I'm hitting wrong buttons. It's crazy. This is Kalkaska, Michigan. This is Judge Mertz, the 46th Circuit Court.
Let's see. And Mr. DeLeo, you're here on behalf of the Probation and Parole Department in this case, is that correct?
Correct, Your Honor.
Okay, so I just want to make sure that I'm clear procedurally on what's gone on here. Mr. Seslick was placed on a delay of sentence in November. And then Mr. DeLeo, you asked to have sentencing on that matter based on a violation of the delay, is that correct?
Correct, Your Honor.
Okay, so then we set a sentencing hearing for April 9th. Mr. Seslick failed to appear for that hearing. So the court executed bench warrant. And so that's why we're here today. Mr. Trush, have you had a chance to speak with Mr. Seslick?
I did, Your Honor. I would suggest to the court, I mean, I think the appropriate step to take at this point is to proceed to the sentencing on the underlying delay at this junction would be my request. Is there a prosecutor, though, in the courtroom?
No, we don't have anybody on behalf of the people here today for this hearing. So I agree with you. The court does need to reset this for a sentencing hearing. Anything else on behalf of Mr. Seslick?
I guess I would just, I assume the court is likely going to set this for the beginning of June. I would just ask the court to address bond in the interim. Mr. Seslick is employed. He does also have some health concerns. So I would ask court to consider bond in the interim. Again, assuming the court's going to set at the beginning of July. I think a small period of release would allow him to get some affairs in order. Thank you.
All right, thank you. Mr. DeLeo, anything input on that from your side?
I would just point out, Your Honor, I mean, Mr. Seslick failed to appear for his original delay of sentence hearing. And then obviously failed to appear when we moved this up and asked the court to sentence him. I know he also had some absconder situations on his felony probation cases out of Genesee and Lapeer counties. So certainly there's some trepidation on the probation department that if he, does post bond and is released, that we'll be searching for him again and yet again delaying getting this taken care of.
All right, so the court notes Mr. Seslick previously failed to appear on March 6th of 2024, April 3rd of 2024. He failed to appear for a hearing on July 15th of 2024. And then it looks like he also failed to appear. Then we scheduled the hearing for November. That's right. I do believe he was lodged during at least some of those failures to appear.
Yes.
However, that has been a pattern with Mr. Seslick. He is under sentence currently. He did enter a plea in this case. So the court finds that at this point, in order to ensure Mr. Seslick's appearance for the sentencing hearing, and to avoid further expense to the taxpayers and continuing to have to issue bench warrants and arrest Mr. Seslick, bring him back to court, the court is going to deny bond at this point. The court's going to order that his bond be revoked and he be held until the court can schedule that sentencing hearing. Mr. DeLeo, in terms of a PSI, was one prepared already for that April hearing?
It was, Your Honor.
Okay, so is there anything that you needed? I'm assuming maybe an update, but is that something that would require, 30 days for you to prepare, or could we do that quicker?
I don't really even think an update needs to be done, Your Honor, other than potential jail credit, but if the court wants me to look into anything, I'm certainly happy to do that.
So, in Your Honor, the court can correct me if I'm mistaken on this. My recollection of my records reflect that ultimately the plea was to a 1-year misdemeanor. So I certainly don't object to having input from the probation department by way of a PSI. But again, I believe that the underlying plea was to a 1-year misdemeanor.
Yeah, yep. So what that means, I guess, for you, Mr. Seslick and Mr. Trush, is the court can, I'm going to try and get this on for a hearing prior to July. If I can get time at the court's June motion day, then we'll get it set for that time so that we can get Mr. Seslick sentenced and on his way, whether that's more jail time or released with credit at that point. So that's how we'll proceed. Mr. Trush, anything further today?
Not on this record, no.
Mr. DeLeo?
Nothing, Your Honor. Thank you.
Okay, that's all for this hearing today, and the court's going to disconnect on this file.
All right, we'll give you guys a couple of minutes to decide if we end on mom or dad today, but in the meantime, we'll go back to Florida.
She'll have a bars to bed aware inpatient and aftercare program. The $250 cost of prosecution and defense, and all prior incomplete conditions that were not completed will be reimposed.
And that's the agreement with the state?
I do.
Ms. Bodiford, you lower your hand, ma'am, state your name.
Shauna Bodiford?
Ms. Bodiford, you heard the announcement of Ms. Beasley, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
It is.
Has anybody promised you anything different?
No.
Are you under the influence of any drugs or alcohol this morning, which would impair your ability to either enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a violation of probation community control plea form. There's a signature over the defendant line. Is that yours?
Yes, sir.
Have you had the opportunity to read that agreement?
I have.
Have you had the opportunity to go over your violation report with Ms. Beasley?
I have, yes, sir.
Pardon?
Yes, sir.
Have you had sufficient time to speak with Ms. Beasley about your violation?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
I am.
You understand that by admitting you violated the terms and conditions of your probation, you're waiving your right to have an evidentiary hearing?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence?
Yes, sir.
You're waiving your right to present any defenses that you might have to the allegations?
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf?
Yes, sir.
You're waiving your right to testify to remain silent at the evidentiary hearing, which would be a decision you'd have to make?
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence?
No. Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Ms. Bodiford, do you feel the admission is in your best interest?
I do.
All right, you agree you violate, and I'll find there's a basis based on her plea to the misdemeanor. I'll find that Ms. Bodiford's admission was freely and voluntarily made after consultation with her attorney. I'm going to accept it. Her probation is modified. She is ordered to enter and successfully complete the AWARE program. This will be a bars to bed, and that's including the aftercare program. Any violation of the jailhouse rules or the AWARE rules can serve as a basis for an affidavit of violation of probation. All conditions that were imposed that have not been completed or reimposed, there's an additional $250 imposed today for the cost of the prosecution of the violation of probation. Ms. Bodiford, you have 30 days to file notice of appeal. If you wish to appeal the judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you. You need to step over and, does she need to speak to the probation officer? Step over and speak to the probation officer. Ms. Spotify, you need to step right up here and speak.
Bailey, if you're talking about that jailbreak down in New Orleans, I believe they picked up a 6th overnight, and they've also arrested. There we go. Arrested CO who helped in all of that. So there you go. So the crowd has spoken. We will go to Judge Dad to wind our day down.
Yeah.
Dion, Patillo.
Okay. Sir, tell me your name. You have to unmute there at the jail, and I will explain what's happening here. You have to unmute that, sir. Maybe call a deputy and tell them. Unless, there you go. Your name?
Deshaun Seals.
What is your name?
Deshaun Seals.
Deshaun Seals. I thought this was Joshua Thompson, Lisa. Do you know anything about this?
I don't know. I'm kind of confused. I don't know what's going on. Why they got me for Woodhaven? I don't know anything about this.
Hang on.
What's his name, Judge?
He's saying Deshaun Seals, right, sir?
Yes, Your Honor.
Is that with an S?
Yeah.
Okay, let me look it up real quick.
I don't think he's even supposed to be in front of us.
I don't see anything.
It's Joshua Thompson.
We're supposed to have Joshua Thompson today. I just assumed that was him.
I'm sorry, sir. I didn't mean to trouble you there.
Can we get a deputy?
Yeah, can you get a deputy for me, please?
I'm the wrong.
So since it's so late, I don't know what happened today. I was going to just enter an not guilty plea or at least have you confer with him. He's not in custody on this. Sir, can you tell me your name? Is that Joshua Thompson?
No, this is not Joshua Thompson. This is Deshaun Seals. Do you have Joshua Thompson?
Yeah, I know. I thought you got up. Is there a Joshua Thompson there, deputy?
Let me make sure. I do have another camera open too. Let me make sure.
Okay.
That's not you. I think he went back up. He said he was done.
You guys resolve yours, or is that still going here? Yes.
AC, he asked me for Joshua Thompson. I want to pick up. So he asked for Joshua Thompson.
All right. I don't know what happened.
He saw her. He's saying this might be that other Joshua.
Lisa, let's just reschedule this. He's not in custody on this. I don't know what to tell him. I'm going to move on to another case here. Dylan James Hall. Dylan James Hall, 25B148-235A and B.
Dion Patillo on behalf of Mr. Dylan Hall.
You gotta keep the voice up, okay? Mute them, Lisa. All right, so for purposes of arraignment on these, possession of a controlled substance
Mr. Hall stands mute and we waive reading of the information.
and possession of a concealed weapon. And now I'll enter not guilty pleas. Now he's going to plead under HIDA on the concealed weapon charge. He's going to plead on under 7411 on the drug charge. True?
Yes.
You have the unique opportunity to keep both of these off your record. If you plead on these, I'll defer the proceedings, set terms and conditions. Your compliant prosecutor will move to dismiss. Do you understand that? Yes. And I will dismiss if you're compliant. Do you understand that?
Yes.
He's had no prior drug charges, correct?
Correct, Judge.
Have you ever been in trouble before, sir?
No, sir.
All right. These are the possible penalties on each of these under local ordinance are up to 500 fines, 90 days jail costs, or all those. Do you understand that, sir?
Yes, sir.
Did you sign, read, and understand an advice of rights form here today?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You understand all your rights?
Yes, sir.
To the charge possession of a controlled substance, how do you plead?
Guilty.
To the charge possession of a concealed weapon, how do you plead?
Guilty.
On April 28 of 25, were you on telegraph near Dixon, Brownstown?
Yes, sir.
What kind of a weapon did you have?
It should have been.
I can't hear you.
A pistol, I think.
Okay. And
I didn't see it all, so
did you know it was there?
not fully, no.
I can't hear you.
Not fully, no.
What do you mean not fully? I don't know what that means.
So Judge, the vehicle belongs to his father, and the weapon is usually in the vehicle. So Mr. Hall thought that the weapon was in the vehicle, but he wasn't 100% sure if it was in the vehicle.
Do you drive that car a lot?
No. No, sir.
When you've been in the car before, is the weapon in there, this pistol? What kind of a pistol is it to begin with, do you know?
Not close, sir.
So did you believe that the pistol was in the vehicle when you,
Not entirely, no. I wasn't fully sure at all.
well, did you ask?
No, they didn't, the whole time when I got pulled over, they wouldn't let me call my dad, nobody, nothing. So
How do I take this plea? I mean,
So Your Honor, I think it's more of a knowledge where.
yeah, knowledge, but he doesn't know if it was in there or not, and didn't check and didn't ask. And what about the drugs? Did you have drugs?
yes, sir.
What kind of drugs? To the charge possession of a controlled substance, I'm gonna ask you again. How do you plead?
Guilty.
Were you in possession of some kind of controlled substance, and if so, what?
Sweet. Oh, marijuana, sorry, sir.
In the car? How old are you?
19.
Is that all it was marijuana?
Yes, Judge.
Let me see this. Where was the firearm located?
Should have been under seat attached to the frame of the car.
Under which seat?
Either the passenger or the driver.
Is it a lockbox?
Yeah.
It's normally a lockbox.
Yes.
So you didn't know whether the firearm was in there or not?
No, sir.
You know, I just don't feel comfortable with this. I don't. I'm sorry. I'll reschedule it. We're not gonna take a plea. And, I'll give you a personal bond. If you wanna go to trial, that's fine. I'll give you $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. You're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs, and you're not to possess firearms or other dangerous weapons. Do you understand that?
Yes, sir.
All right. Let me just see here. So we'll give you another pretrial date. You're gonna have to fill out a petition for a court-appointed lawyer at this point. Do you understand the bond conditions that I gave you?
Yes, sir.
Do you have any questions?
No, sir.
We doing June 2nd, Lisa?
June 18th at 9:30.
June 18th at 9:30. Okay, sir? You go down the hall, get your notice, fill out your petition for a court-appointed lawyer. You understand what I'm saying? No marijuana, no alcohol, no illegal drugs, and you're not to possess firearms, okay? Thank you very much. Good luck. Thompson, did they leave on that, Lisa, Josh?
So that one's a little bit messy because, you know, I kind of agree with you, Bailey, that maybe he should go to trial. In the same respect, he was going to plead under HIDTA, which we hear a lot of in the Michigan courts, but I don't know if everybody understands what it is. So specifically, HIDTA is HYTA, Holmes Youthful Trainee Act. And it's for defendants between 17 and 25 who have committed certain offenses. If they plead guilty to the offense, the judge does not take that plea. He sets it aside. They go on probation. If they complete the probation successfully, at that point, the case is dismissed and the record is sealed. So, well, this whole thing's a mess. If he could manage to still negotiate a plea under HIDTA that the judge would accept, it's probably the best bet for him in the long run, because everything would be dismissed and it would be sealed and there would be no risk of things going south on him during a trial. So I guess we'll see what happens there and if we can catch the final outcome when he comes back. Anywho, we'll go ahead and leave it there for today. I hope you all had fun. I know I did. Hope you all members enjoyed the pre-show. Again, during our pre-show today, we talked about all the people I know who are in prison, and it is more than one. So there you go. If you want to be able to join us on the pre-show, we would love to have you there. You need to be a member for that. It's $2.99 a month. There is a link in the pinned chat where you can do that. Also, there's a link in the pinned chat to sign up for our newsletter. I know I've been promising that. It is delayed slightly because I'm not happy with the format of it yet, so I'm still tweaking it, but hopefully soon. But in the meantime, if you sign up, I would love to have you as part of the newsletter as well. And it is free, and your email is safe with me. So there you go. All right, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, and a half an hour earlier for channel members. Again, I hope you all had fun. I appreciate every single one of you who join me every day. And those of you who are here for the first time, glad to have you. At the very least, please do hit the like button on the way out. And if you're not subscribed to the channel, please consider doing so. We'll see you again tomorrow. Take care. God bless.